when I have a husband and wife come in and they have what appears to me separate and community property, of course I discuss post-marital agreement, and it gets wiped away really quickly. I wish it didn't, because I'd be perfectly happy if it was done. But I suggest a two trust approach. The separate property going into the single trust of one spouse, and the joint property going into a joint trust. And in one of the paperwork that the clients sign, they'll be signing saying that this is not in lieu of a post-marital agreement. Because I suggested you enter into one with two separate lawyers, but at this time you declined. And I also indicated that with this two trust approach, we're not doing waivers. So if I put a certain asset in the single trust or another asset in the joint trust, I'm not having anybody waive, anything about anything, it's not doing that does not get them in the same place as if they had a post-marital agreement. But I'll tell you, I'm going to tell you why I still think that that's good. And that is these tracing rules. When somebody wants to trace the separate property, we'll see later cases where that person has the burden of proving, of doing the tracing. So you say, well, wait a minute, you have this husband and wife joint trust. The husband has the separate property. He deeds it into the trust. He doesn't convert it to community property. So if they get a divorce, there's no tracing problem because you've got the deed putting it in. You don't have to hire forensic accountants, et cetera. I say, but if between the time the trust is set up and the divorce, that property is sold, then you've got that money in the trust, and that cash, stock, or whatever is like all the other money in there. And what kind of record keeping is the client going to keep within the trust from the sale proceeds of the separate asset as compared to the liquid community property assets? And the answer is, I don't know, but my real answer is probably very little or no record keeping. So that's one of the reasons that I don't like muddying up the situation with one joint trust. And I guess you could say to the client, I'm not going to do your estate plan because you don't want to do a separate trust, or you could have them sign something saying that you recommended a separate trust and they declined. That would be certainly better than nothing. So 3B, the estate planning attorney testified during the divorce that she explained to the couple the advantages of the step-up in basis upon the death of the first spouse. To me, in reading the opinion, it sounded a little bit more like encouragement rather than just explaining, because you can explain and then you've got a bunch of letters talking about the fact you can't do it, that it needs to be done in a certain way that you're not going to get involved in. But whether it was explained or encouraged, certainly the couple learned about it. So C, estate planning attorney testifies during the divorce that she did not recall having a specific discussion about divorce law. So this is very common, that you bring up something, you bring up the advantage, and then the elephant in the room, the big topic, what effect it has on divorce, didn't even get discussed. And here, the estate planning attorney, by testifying to that, I'm not a malpractice attorney or tort lawyer or whatever, but certainly that's pretty damning testimony for the lawyer if they're going after him or her later, or her, I think. D, the couple instructed the attorney to change the character of the husband's assets from separate to community. But again, the couple didn't walk in with that idea, and the question we have for estate planning side is, what is the scope of our representation? And there's a question: do you not tell the client so that they're not tempted to bring this up, or do you tell them about the rules and tell them you can't do certain things but you can do other things? I think the latter is better than not bringing it up at all. But to me, the worst of all is bringing it up and then just moving forward without discussing the divorce aspect of it. E, the attorney drafted and the couple signed an agreement stating that all their property is community property and a transmutation under Family Code 852 is intended as the separate property. Well, 852A says a transmutation of real or personal property is not valid unless made in writing by an express declaration that is made, joined in, consented to, or accepted by the spouse whose interest in the property is adversely affected. Well, I hope that estate planning lawyers believe that they don't know what an express declaration is, because I sure don't, because every time I read a case, it surprises me as to what is and isn't an express declaration. So if somebody, the estate planning lawyer, the family lawyer, or somebody, the mediator, or whoever is going to do this transmutation, they better hit it really hard, because that case may be the next new case, trying to figure out if those words were or were not an express declaration. But I think estate planning lawyers take maybe too lightly this issue of transmutation, as if it's easy and that you're going to do something and it'll be universally recognized. But in this case, the transmutation was recognized, because the right words were used, the magic words, and then the agreement waived the Family Code Section 2640 reimbursement right, and that was also clear and not questioned. And under 2640 of the Family Code, unless a party has made a written waiver of the right to reimbursement or has signed a writing that has the effect of a waiver, the party shall be reimbursed for the party's contributions to the acquisition of property of the community property estate to the extent the party traces the contributions to a separate property source. So the estate planning lawyer wants to get as much of the deeding history as possible from the time the property was originally purchased onward. And even that may not be enough. And I'm going to give you an example of that later, but it might have been bought by one spouse as separate and put into community, but it may be bouncing back and forth, separate to community, all over the place. And so you have all these different bounces, and then maybe it's only the last bounce that winds up with this reimbursement right when it went from one party separate to community, and then for purpose of divorce only, you've got this reimbursement right, but you don't have a reimbursement right for death. So if you have a revocable trust where the survivor gets everything, even though the deceased had this reimbursement right, it never kicks in because there's never been a divorce. So this 2640 is very scary section for estate lawyers. The family lawyers know it cold, because you're going to use it as much as you possibly can because you've got your client, or you're going to combat it if you're on the other side of it as much as you possibly can.